So that's what probative value means. But what do we do with the probative value? Well, Rule 403 says that the court may exclude evidence, even if it's relevant, if the probative value of that evidence is substantially outweighed by a danger of one of these things, right? Unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. All right, so let's talk about what these things are. And the first one is unfair prejudice. Unfair prejudice. All right, now, all evidence is prejudicial. I mean, that's the whole point of evidence. It's to try to make the jury tend to think that something is true or not true. Okay? If it doesn't cause any prejudice, then that just means that it has no tendency to make a fact more or less probable. But if it has no tendency to make a fact more or less probable, well, that just means that it's not relevant. Okay, so all evidence, all relevant evidence anyway, all evidence causes some prejudice. But what we're talking about here is unfair prejudice. Unfair prejudice. Something is unfairly prejudicial if it tempts the jury to decide something on some basis that's actually different than what the jury's decision should be based on. All right, so let's say, for example, that there's some evidence in a criminal case. Okay, we have a criminal defendant here, and there's some evidence that he is a white supremacist. Okay, say there's a picture of him with his shirt off and a large swastika tattooed on his chest. All right, now for many, many people, that symbol is going to cause a pretty visceral reaction. Okay, a jury might be tempted to want to convict him, not based on whether the evidence actually proves that he committed the crime, but just based on how they feel about him more generally, now that they think he's a white supremacist. Okay, and that's probably going to be the case, even if his racism really doesn't have anything to do with the alleged crime. Now, in that case, the evidence that shows him to be a white supremacist, that's probably unfairly prejudicial, because there's a very good chance that the jurors will be influenced more by their emotional reaction to this symbol, right, than they really are by a careful weighing of the evidence. And we don't want that in a trial. Okay? We want to make sure that trial outcomes are based on the right things, on the evidence that really tends to prove or disprove the facts that matter. Right? Not based on whether the jury likes or dislikes a party, or feels sympathy for a party, or any other emotional reaction that is separate from an objective weighing of the evidence. Okay, now we can actually plot the danger of unfair prejudice. Okay, so let's draw sort of a parallel plot to what we had here for probative value. All right, so let's mark this as danger of one of those listed things. Okay, danger of. And let's see if we can draw a line that's as straight as the one we had before. Okay, so all right. Okay, and for our first example here, we were plotting how prejudicial this would be. Okay, so let's say we think that's pretty prejudicial, unfairly prejudicial. Okay, so that's unfair prejudice. All right, now the next ones, confusing the issues, misleading the jury, those kind of overlap. All right, let's underline those as well. Okay, confusing the issues and misleading the jury. Okay, they're listed as two separate items, but they kind of overlap. It's because the reason we don't want something to confuse the issues is because, well, if that were to happen, it would likely mislead the jury. Okay, so it's probably easier just to think of these two things together. And we can also plot the danger that a piece of evidence will be confusing or misleading. So let's do that too. Okay, so let's say that there is some danger of confusing the issues or misleading the jury. Okay, it's just not that straightforward, and a jury might hear evidence about one thing and think that it applies to another thing. Okay, so that's another risk of evidence. Okay, there can be some danger that the jury will be misled, that will it'll interpret that evidence in that wrong way. All right, and finally, the last ones are undue delay, and we'll underline these too. Undue delay, wasting time, or needlessly presenting cumulative evidence. Okay, and here again, we can probably think of these things together because they're really just talking about the same thing, wasting the court's time. All right, and the easiest example of this is probably the last one, needlessly presenting cumulative evidence, right? So if we need to prove, let's say, that the sun was shining on a particular day, it's probably enough just to look at the weather record for that day. We don't also need to take testimony from 15 eyewitnesses about their recollection of the weather that day. All right, that would just be needlessly repetitive and a waste of time. Okay, so well, let's plot that one too. Okay, so let's say that one is also, there's a high danger of wasting time. Okay, so we've got two plots going on here. All right, so in the Rule 403 test, what we do with the probative value here is we compare it to the danger of one of these things, the unfair prejudice, confusing the issues, etc. Okay, and we try to see how they measure up against one another. That's why I said earlier that people sometimes refer to the Rule 403 test as the probative versus prejudicial balancing test. Right? It's not just the prejudicial, though. It's the probative versus any of this other stuff test. Okay? So we're weighing the probative value. Okay? We're weighing these things against each other. Okay, so we put them on a scale and we just sort of weigh them against each other. All right? And you know, what we're looking for is seeing whether the probative value of a piece of evidence outweighs the danger of one of these things happening, or vice versa. Okay, now, as we weigh these things against each other, there are a few things to keep in mind. Three things to keep in mind. Okay, and maybe I'll, well, let's go in order. All right, the first one is just recognize that this is sort of like comparing apples and oranges. Right? Maybe I should jot these things down. Okay, so a few wrinkles about this. One, remember that this is sort of like apples and oranges. And what I mean by that is, well, they're two completely different measures. Probative value is a measure of one thing, and the danger of one of these things happening, well, that's a completely different measurement. It's like comparing intelligence to height. It's not like somebody who is very tall is necessarily going to be very intelligent, right? They're not mutually exclusive. So there are tall people who are very intelligent and tall people who are not so intelligent. And there are short people who can be intelligent or not so intelligent. And we have every possible combination in between as well, right? It's not like knowing someone's height gives us any clue about their level of intelligence or vice versa, right? Similarly, the probative value of a piece of evidence and the danger that the evidence will cause one of these other things, they're completely unrelated. Okay, say we have a piece of evidence that has a very high probative value, like we did here with this red one, right? Well, that's okay, that's great. But the fact that the evidence is very probative doesn't actually tell us anything about the danger of one of these things happening, right? The evidence might pose absolutely no risk of causing unfair prejudice or confusing the issues or any of these other things. Or it might present a very serious danger of causing one of these things, and vice versa, right? So just because something has a very high tendency to, or a high danger of one of these things happening, that doesn't really tell us anything about how probative that evidence is. Let me give just one example here. And actually, let's go back to our defendant here with the swastika tattoo. Okay, let's say that criminal trial was for check fraud. Okay, he was accused of committing check fraud. Well, in that case, we talked about how that swastika tattoo is likely to be very prejudicial. It really doesn't have much probative value to whether he committed check fraud. Okay, and so in that case, I would say that the danger of unfair prejudice probably pretty significantly outweighs whatever probative value there may have been. On the other hand, let's say that the trial was for a racially motivated assault. And even more so, let's say that there was an eyewitness who said, I couldn't really make out who the assailant was, but I did see that he had a swastika tattoo on his chest. Well, then, in that case, this evidence about the tattoo on his chest, it shows a couple of things very strongly, right? It has a pretty high probative value. It shows that, one, he very likely was racially motivated, and two, that he was the same guy because he's got that identifying tattoo on his chest. So, same prejudicial effect, but in the second example, a much higher probative value. All right, so please keep in mind that just because probative value is high, that does not necessarily mean that the danger of one of these things happening is low, and vice versa. All right, that's the first wrinkle. The second wrinkle is that this weighing requires us to consider whether the danger of one of these things happening substantially, my spelling is problematic here, whether the danger substantially outweighs the probative value. Okay, so it's not like we're just looking for which one is slightly higher than the other. In order for this relevant evidence to be excluded under Rule 403, the danger of one of these things happening must substantially outweigh the probative value. You know what that means is, if a piece of evidence has a very high probative value, it's going to have to be extremely prejudicial, or there has to be a danger of an extremely high danger of confusing the issues or wasting time for that evidence to be excluded under 403. And finally, let's do number 3 here. Okay? And finally, the rule says that the court may exclude this evidence. All right, so if the danger of one of these things happening does substantially outweigh the probative value, in that case the court may exclude it. In other words, the court has discretion. And it's probably a good thing that the court has that discretion because, again, these are like comparing apples and oranges. So there isn't sort of like a very easy mathematical test that we can apply to say, yep, this piece of evidence definitely has a danger of unfair prejudice that outweighs the probative value. It has to substantially outweigh the probative value, and even then the court, in its discretion, may choose to exclude that evidence if it really feels like it's going to do more harm than good.